Senator Risch has agreed to pass for the time and move to Senator Cornyn.
Congratulations, Mr. Wiegmann, on your nomination.
Thank you.
And thank you for your service to our nation in various capacities before this. I want to talk to you a little bit about 702 since it's come up, and that you're intimately familiar with it, as well as the operation of the Foreign Intelligence Surveillance Court. Unlike a traditional adversarial process, a criminal trial, for example, where you have a prosecution and defense, the Foreign Intelligence Surveillance Court largely operates on an ex parte basis, correct?
That's right.
And what does that mean?
That means that the government is there, but there's no party on the other side.
And that means that the target of a, let's say, a warrant, somebody overseas, or other interested party whose rights may be involved, they're not invited to present an argument to the court that's decided in what I would call a traditional adversarial process, right?
That's right, although I would point out that that's the same in the criminal context. If you're doing a Title III
Right.
wiretap or a search warrant, the other side doesn't know about that in that context either.
Thank you for pointing that out. Yes, this is standard operating procedure in the criminal courts where the government seeks a search warrant or a wiretap or something of that nature. Of course, those can be reviewed on appeal in the event of a conviction.
Right.
But as you know, the current law on the amicus curiae, friend of the court,
Yes.
allows the Foreign Intelligence Surveillance Court to consult with an amicus on novel questions of law. That is a process where the court initiates it, asks the amicus, would you care to weigh in to help us make a better decision? Is that what you understand to be the current state of the law?
Yes, that's right.
And you're aware of the fact that there were discussions leading up to the last authorization, and in fact, those discussions continue about let's say a more an amicus role that is much more of the nature of an adversary as opposed to just a friend of the court. Are you familiar with that?
Yes, I am.
For example, in the provisions that were not included but are now included in the Intelligence Authorization Act, which is a public document, would allow the amicus to actually appeal from some of the decisions of the Foreign Intelligence Surveillance Court. Is that right?
I know that that's been proposed before.
And well, I would invite you to look at the what passed out of the committee on the Intelligence Authorization Act. I think you'll find that some of the proposals that were not included are now included, which provide for a amicus role, which basically makes them a party to litigation and enables them to appeal to an appellate court the decisions of the Foreign Intelligence Surveillance Court. But let me just ask you about the practical operation. Is frequently in intelligence operations, is there a need for speed?
Yes, sir.
And would the prospect of a protracted litigation, including an appeal to an appellate court of decisions made by the Foreign Intelligence Surveillance Court that ordinarily would be made on an ex parte basis, to allow those appeals to proceed and perhaps slow down the collection of national security intelligence? Is that a concern of yours?
Yes, it would be, sir.
So years ago, General Hayden, who was head of the National Security Agency and, of course, CIA director, wrote a book, which I enjoyed quite a bit. But the title of it was called Playing to the Edge. And, of course, it's your job to say what the edge is to the people that you work for. But unfortunately, we've also seen a political consequence where intelligence officials play to the edge, that is based on sound legal advice given to them by people like you and others in the national security interest, to try to get all the information they can legally get under the current authorities, and then are later held to account, or I would say hung out to dry, by the political branches when maybe it turns unpopular later on. Are you familiar with some of what I'm referring to?
Yes, sir, unfortunately.
And so what's your view of playing to the edge?
So
The appropriate way to play to the edge as a chief counsel for the Director of National Intelligence.
So look, I see my job as a lawyer is providing my best view of the law. Sometimes there are gray areas, and when you can make legal arguments that you think are supportable, that's something that becomes a policy choice essentially for the client to make. If you have a good and defensible legal argument that people may disagree with, then and if national security requires it, then that may be something that they can have discretion to do. But there are other cases where it's like, well, there's really not an argument here, and while it might advance your interest, you may have to do it, or you may have to come back to this committee or Congress to get additional authorities or something different. So that's kind of how I see my job, is making clear when the law draws a red line and says that's just not something you could do, and when you have space to make a decision.
Thank you.